Good morning. Welcome to WG Hub Live, your usual Friday morning session, 10 o'clock here. Ward Goodman, hope you have got your coffee ready, settled down for an hour's session on our special today, landlord and tenant issues in the current environment and beyond. Obviously, all our sessions at the minute focusing a little bit on the COVID-19 pandemic element. So this one's about property, it's about landlord and tenant issues. I'm glad to see this morning that we've still got our regulars with us, and I hope you enjoy this one today, and welcome to all the new guest viewers on this Hub Live. So this morning, I'd like to just welcome our speakers and our panelists. So this morning, our main speaker, Robin Cole from is a commercial property lawyer from Blanchards Bailey. I think it's fair to say, Robin, you've been around a bit.
Yes, I'm happy to admit that, and I think I've got a few more miles left.
Fantastic. But Robin, an absolute expert in his field, and we now call him the Mythbuster. So here he is today, coming on to bust some myths about the current situation and to give us a good overview on the legal framework. What's out there for you, and you know what might come up and bite you in the backside. So here we go. We also have this morning, very pleased to bring on as a panelist today, Mr. John Baker. Good morning, John.
Good morning.
Morning, John. So John's well through his involvement with the RICS, and that he's a proper recognised property man, lots of experience, and so I'm glad you could join the panel today, John.
Good to be here.
And as you'd expect from Ward Goodman, we do cover a lot of areas of finance. We're right across the spectrum of financial matters. So a lot of our clients actually are also involved in property, because property covers the full spectrum with regards financial matters. So I'm really pleased this morning to have one of our really valued clients, Myra Davies.
Good morning.
So Myra owns Arquero Property Management. And we can, she has a lot of experience in a property management role, and she's going to bring some different elements to the panel, and hopefully we can ask, get a lot of questions. I can't see our own Stephen Martin this morning, but he may come on in a minute. But there we go. So he may come on as a panelist a bit later. So without further ado, I think we're ready for you, Robin. Usual rules apply. Send the Q&As through to Robin and our other panelists. Use the Q&A function. Hopefully you can see that on the sort of bottom of the screen. There is a chat box there as well. But put the Q&A questions as we're doing the presentations. We'll ask for all the questions at the end. And yeah, so without further ado, Robin.
Okay. Let's see if I can just pull up a PowerPoint. Okay, I hope everybody can see that.
Yeah, it's great.
I need to put that on. Next slide. Okay, so in about in no more than 15 minutes, I'm going to run through fairly high level the coronavirus legislation as it affects commercial landlord and tenants. It's a difficult subject, which needs to be treated with some circumspection. Both landlords and tenants are hurting right across the country, and so I'm going to try and maintain a fairly neutral stance over the effects of the legislation. Have a look at the impact of the key changes, most of which are temporary, and then try and apply those or put those in the context of current commercial leasing issues. And then I thought we'd have a quick look at the code of practice for commercial property relationships during the COVID-19 pandemic, an august and industry accepted code of voluntary status, but which has some clues as to how the government at any rate are expecting us to behave. So here are the key areas of legislation to look at. All of you will be familiar with the Coronavirus Act 2020. It was fast-tracked and got royal assent on the 25th of March. And the thing that followed it promptly, for reasons which I'll explain in a moment, is the Corporate Insolvency and Governance Act, which is not primarily to do with landlord and tenant relationships. There's a lot of very good stuff in there about moratoriums and other related insolvency provisions, which are actually were in the melting pot. But it contains some key issues that we need to have a look at. And then a big shout out for the Business and Planning Bill, which has passed its second reading in the House of Lords, committee stage on the 13th of July, where there'll be a line-by-line examination of the issues in it. And so far as that bill is concerned, it's not specifically about landlord and tenant or specifically about any aspect of specialist real estate, but there are some essential planning preservation changes in that legislation which are going to be very welcome for those who are developers. I'm not going to deal with that today. That's a topic of its own right. And then, as I say, we've got the Code of Practice published in June. It's voluntary, but it was worked up by the British Chamber of Commerce, the Retail Consortium and the RICS. And it includes signatories from a wide range of landlord and tenant groups, including from the agricultural sector and the British Kebab Alliance. So it shows how deep and wide-ranging consultation was apparently in relation to that code. So here we are. Here are the key issues on these two fast-track legislation items. The first is what I think will already be well known to you all, and that's that there was a moratorium on commercial landlords enforcing forfeiture of leases for unpaid rent. Initially, that was to the 30th of June, and that's now been extended to the 30th of September. So I need to go back now, I've gone overclocked. For reasons that are not immediately apparent, the government became aware of what I think we already knew, which was that statutory demands were widely used by landlords as a precursor to winding up, as a means of trying to collect rent from apparently miscreant tenants. But of course, that was an easy workaround, the forfeiture provisions, because a winding up petition would inevitably induce the tenant to pay in circumstances where, we ought not at this stage to be chasing it. The Minister said it was not intended to be used as a tool for debt collection, but I've never known it used for any other purpose. But the effect of the Insolvency Act provisions was to prevent winding up proceedings being taken on the basis of a statutory demand. Now, that is not to prevent winding up proceedings being taken. And in fact, under the deemed insolvency provisions in Section 123 of the Insolvency Act, there are three that are particularly relevant to UK companies, and only one of those is the use of the statutory demand. But as I say, that's completely banned until the 30th of September. The other provisions, which are set out in Section 123B and E, are judgment debts, which one's attempted to enforce. That would normally induce a petition for winding up without a statutory demand. And on Section 123E, that a creditor proves to the court that a company is unable to pay its debts, otherwise than by reason of a judgment debt. Now, in those two cases, the creditor has to prove, and I'm going to keep this fairly high level because the subsections are convoluted, but fundamentally the creditor has to present reasonable grounds for believing that the coronavirus has not had an effect on the company which is the subject of the winding up proceedings. And in the case of subsection B, the facts by reference to which the relevant ground applies would have arisen even if the coronavirus had not had a financial effect on the company. So it is still possible to seek winding up arrangements, but only where there was a settled and hopeless expectation of insolvency before the coronavirus pandemic took effect. So that's in a nutshell for winding up. But what has been overlooked and is extremely important, particularly to hard-pressed tenants at the moment, is the provisions relating to wrongful trading. Now, many of you will know that there is personal liability on directors to contribute to the assets of an insolvent company on the application of a liquidator or receiver if his loss has not been, if he didn't mitigate his loss. And that's a particularly potent concern, because it has tended to have the effect of people giving up rather earlier than they normally would. And the whole purpose behind the Insolvency and Governance Act is to try and keep people alive in business terms for long enough to survive the crisis. Now, all of the powers in those two acts can be extended. They're time limited at the moment, 30th September. And very unusually, the powers in the Act actually give the government the opportunity to change both primary and secondary legislation through statutory instruments. And that's a very unusual power in a democratic world. But that's what it is. There is some justification around it, but the government has wide sweeping powers to keep this legislation alive and even to change it. Okay, so how does that all fit into the sorts of things that that tenants are struggling with and landlords are struggling with at the moment? Well, the first one I want to get rid of is the doctrine of frustration. Now, obviously, a great pool's win, a hope for many a tenant, but if I can just nip this one in the bud, there's a well-known case called Panalmina. To claim that the lease is frustrated so that you can bring it to an immediate end involves a wide-ranging test. Very, very difficult. It's possible, but there are very few reported cases of that being successful. So I just want to knock that one out. The prospects of success are next to zero. Now, lots has been talked about in all sorts of settings around force majeure, whether a tenant would be entitled, for example, to a reduction of rent or a deferral based upon some force majeure principle. Well, the bad news, I'm afraid, is that force majeure is a creature of contract law and not of common law, and that means that commercial leases would need to have a contractual right built in. Now, suffice for the purposes of this discussion, at any rate, to point out that UK institutional leases never contain a force majeure provision. So I think I'm sorry to say that there's no genuine basis in the conventional landlord and tenant lease on that ground. And that leads me to look at the provisions relating to set-off, namely whether a tenant could in some way mount a counterclaim for failure of services or reduction of dependent resources of one kind or another, or a failure to make the premises available if that were a legislative consequence of the legislation. Well, the institutional lease setting contains a no set-off provision either in contract or in equity, and so I'm afraid for reasons that are largely to do with landlords seeking to have a triple net rental stream which can't be interrupted, there's no ability to set off any claims that you have on one hand against your liability to pay the rent on the other. So I think we then need to work out from a landlord and tenant perspective how to mitigate some of the effects of the legislation. And I'll deal with the code of practice and the rent concession arrangements, which we are seeing now in a variety of forms come across our desk daily, both landlords instructing us to help them draft it correctly and also to get the right nuance, and for tenants. And in every case based upon the particular circumstances of the parties involved. But I just want to concentrate for a moment on break clauses. This is a difficult subject for tenants because tenants who insert break clauses when they negotiated their leases may well want to implement them whenever they next become available. And I cannot stress enough how important it is to check the exacting nature of the obligations surrounding the break. Normally there's a notice period that has to be strictly complied with. And then there are still a wide range of leases out there where the conditions precedent for successful breaking of your lease depend upon a number of performance criteria. More modern leases, I think, between landlords and tenants, we've come to understand that it's fairer that conditions precedent are possibly limited just to the payment of rent and also the delivery of vacant possession. And when I say rent, I mean rent, service charge, insurance, rent, so that there are no arrears of any financials.
Okay, well, we appear to have lost Robin. Sorry about that. We'll see if we can get him back. In the meantime, I think perhaps we could ask a few questions if anybody's got any questions at the minute. Let's see.
I could jump in with what Robin was talking about, break clauses.
Fantastic. Thank you so much.
No problem. I echo what Robin has said because older leases and drafting of tenant break options often used to contain some fairly onerous preconditions. So it really is important. And there's been lots and lots of litigation and case law surrounding break options. Things like where a break option has required a tenant to deliver vacant possession and they've left some demountable partitions. Yeah, potentially that could frustrate your ability to serve a break. So it is important to get proper advice and follow the any conditions that attach to it. And the other thing to bear in mind, it's often a threat that a tenant makes to, well, I'll exercise a break unless there's some sort of adjustment to lease terms. Just be careful. Once a break clause is exercised, you can't withdraw that break option. You can't say, okay, I've changed my mind. The landlord's given me an extra rent free. I'll withdraw the option to the exercise the break. You actually have to, strictly speaking, go back and draw up a whole new lease. So it's sort of irrevocable once you do it. So get some good sound advice in if you're contemplating exercising a break option. But break options also present opportunities to both landlords and tenants, especially in the current market. There's the chance for opportunity for exploring lease re-gears. And if a tenant is happy to either take out a break clause from a lease or push it back in time, then a landlord may well be prepared to grant some sort of concession because their investment value increases. And it means that the landlord may not fall foul of loan to value ratios on properties. So there are some opportunities out there for dealing with lease re-gears that act in both interests for landlord and tenant.
Right, yeah. What is there much going on you talked about the break clauses? How are people setting them up now? Are they thinking differently now with COVID?
Typically, as Robin mentioned, typically break clauses in leases require tenants to give a minimum notice period. So it's usually at least 6 months notice in writing. And of course, COVID hasn't quite been around that long and they're normally set dates. Sometimes you'll get rolling breaks that can be operated at any time on 6 months notice, but normally they're on set dates. So it's not necessarily a feature that I personally have come across. I don't know whether Myra has. Myra might have tenants that are suggesting that they might exercise breaks unless there's some sort of concession involved.
Not at the moment. We have had this before, when the last recession happened, that tenants did actually use the leverage of the break option to negotiate better terms for them. And in most of our cases, the landlords were amenable to that because it secured their investment. One thing that we have had crop up is moving off of the break options is with regard valuations. It's just be careful when you get your valuation with your property revalued, because a lot of valuers are taking into account how much rent is being paid at the moment. So
thanks, Myra. Stepping in. John, it looks like we might have Robin back. So
You have.
hey, well,
You have. I've successfully.
I mean,
I've used the defibrillator, and I'm back in action.
Yeah, we hadn't reckoned on a small sort of comfort break, but hey, there you go, Robin.
Found out at last.
Off you go.
Do you want me to carry on, or have you?
Yeah, please do. We're just talking a little bit about break clauses. Yeah, John stepped in with a little bit about what's going on with breaks at the moment and that sort of thing. So followed on from what you were discussing. So please carry on with the next bit.
Okay. Sorry, I've just got to click through now. Okay, so I probably don't need to. I think we probably stressed enough the need to get these break clauses right, and it's not just the service of the notice, which also poses its own difficulties, but also ensuring that you've met the relevant conditions. And I think the ones that I would stress. The need to provide vacant possession if that's a condition. And that means that you've got subtenants who are ex-Landlord and Tenant Act. And there's a nasty case called Morant Property, 2009 case, where the tenant failed to return the keys on the break date because he had contractors in there carrying out some dilapidations work. He was deemed to have failed to meet the conditions, and was that the break was deemed to be invalid. So I think probably we ought to talk about rent concession arrangements and rent deposit deeds. The code of practice, which is a document worked up in all good faith in extremely difficult circumstances, urges landlords and tenants alike to operate with transparency and good faith, taking full account of their respective needs, but favouring neither. And in many ways, in fact, the code has validity. I think it's until the 24th of June 2021, and without in any way belittling it, because it's a worthwhile read of what constitutes fair and reasonable dealings between the two parties. But the key to it is that it doesn't, and stresses that it doesn't in any way interfere with the contractual relationship which exists between landlord and tenant. So it's how to behave nicely is the guts of it. But it does contain some worthwhile and important suggestions. And one of those obviously relates to the way in which rent concession arrangements ought to be thought about, and what should happen in relation to rent deposit deeds. Now, you can appreciate that the vast majority of tenants who have entered into rent deposit arrangements, cash is deposited with the landlord, which can normally be drawn down on written notice. And the typical one, of course, is the non-payment of rent. The problem with those deeds is that they immediately induce a separate obligation, if well drafted, for the tenant to top those rents up. And then, which obviously is self-defeating because, for obvious reasons. So the code suggests that landlords shouldn't ask tenants to do that. But as I say, there's no contractual limitation on the ability of landlords to do so. And I think I'll pass on service charges just for a moment to talk about guarantees and ARGAs. Now, there are a wide range of circumstances that potentially bring third parties into play in relation to tenant liability. And they obviously break down to existing guarantors and also recovery from former tenants and their guarantors. And it's worth reflecting for a moment that in the case of former tenants and their guarantors, one needs to look very carefully at the Landlord and Tenant Covenants Act 1995. And yes, it is still possible that you've got to think about whether the lease is an old lease under the 1996 legislation or a new lease, but in most cases they will be new now. So I'm going to pass over the old ones. The essence of the of applying for rent payment by a former tenant or its guarantor is that you have to comply with Section 17 of the Landlord and Tenant Covenants Act. And it's in a prescribed form, and critically, you need to make a claim as a landlord within 6 months of what's called a fixed charge falling due. And that fixed charge includes rent, service charges and other liquidated sums and interest. And failure to serve that Section 17 notice within the 6-month period results in the landlord losing its right to pursue those who've retained liability for any breaches of covenant to pay fixed charges by the current tenant. A former tenant or guarantor that receives a valid Section 17 notice is required to pay the arrears and any interest as set out in that notice. And so there are going to be, if you follow this route, a series of notices. But there's a sting in the tail, and that is that before serving a Section 17 notice, the landlord needs to be aware that a former tenant or guarantor who pays all the sums due in the notice becomes entitled under Section 19 to an overriding lease, which sits in between that of the landlord and the occupational tenant. And that new lease converts the existing tenant into a subtenant, and that allows, the principle behind it is that it allows the former tenant or guarantor to pursue the existing tenant for the debt, including by seeking to forfeit the lease, subject obviously to the restrictions that we're talking about at the moment. So I just point out that if you are going to pursue former tenants or their guarantors, that the landlord should only serve that notice if it's prepared to have a tenant going forwards under an overriding lease. I suppose under this heading I should also really deal with the recovery of rent from subtenants. Now the procedure there is set out in the CRA procedure, and it gives the superior landlord a right to serve notice. I think it's Section 81 actually of the, I'm going to forget it now, I think it's the Tribunal Courts and Enforcement Act. And it requires the subtenant to pay the rent directly to the superior landlord rather than the landlord, to the extent of the arrears due from that immediate tenant. And if the subtenant fails to do so, the superior landlord can exercise CRA and other remedies against it, so far as they are also not restricted by the coronavirus restrictions. Importantly, the landlord can only serve a valid Section 81 notice on the tenant where it's entitled to exercise CRA against the existing tenant. I mean, I should point out that from the 24th of June, the landlords are prevented from using CRA unless an amount equal to 90 days rent was overdue. Well, that was originally, now it's become at least 189 days. So the mathematicians will work out that rent that was due on the 24th of June couldn't be subject to a CRA procedure before the 31st of December this year. So that probably covers the key points around guarantors and enforcement, collecting rent from subtenants. So I'm just going to just to recap about enforcement before we go on to the code. Payment obligations are not suspended. There's no aspect of forgiveness or waiver involved in the legislation. And default interest is still payable, insurance, rents, service charge, everything is still payable. The enforcement arrangements around these are deeply suspended, as I've described. And one could be forgiven for recognizing that we have kicked the can down the road royally. But on the other hand, there's been a realism about the legislation, and we've to hope on behalf of both landlords and tenants that arrangements can be made which enable the survivable to survive in the current circumstances, and that may involve further extensions and modifications to the existing legislation. There's a stay of all proceedings, by the way, for 90 days until the 23rd of August, under a change to the civil procedure rules. And as I say, there's a stay on seizing tenants' goods under the taking control of goods and certification enforcement agents amendments. And that applies until the 30th of September or later date as specified. So moving on really to the code, and I hope I haven't been too disparaging about the code or unfair in any way, because it has been put together in a genuine attempt to enable landlords and tenants to understand their respective predicaments. But I just wanted to take you through a number of key quotes from the code. I've actually, I think I've attached later to the presentation, which is available to you afterwards, the full text of the code itself. But anyway, here it is. The tenants are liable for covenants and payment obligations unless renegotiated. Tenants who are in a position to pay in full should do so, and tenants who are unable to pay in full should seek agreement. Now, we have had large numbers of tenants seeking help, and initially at least there has been a groundswell of openness amongst many landlords to the predicament that tenants find themselves in. But I can't stress enough that the key to a successful discussion here is all about putting forward a business impact case and being prepared to demonstrate how and why you can't meet your obligations, and why it is that you think you will be able to meet them in the future, and how to deal with them in the meantime. This is not an easy subject because of the lack of visibility amongst tenants in terms of where their businesses are going. But nonetheless, that conversation has to be had, and frequently landlords are asking quite intrusive questions to establish that tenants are genuinely in hardship. And I think you should, if I can encourage you to be as open and clear about what your circumstances are, and not in the least reticent about bringing forward that information, it will help your negotiation without any doubt. I'm just going to move on to the next one. Here comes, so here's the principal aspects of the code. All of these are relatively predictable. Landlords are asked to consider waiving default interest on unpaid rents. they're asked not to seek top-up arrangements from the rent deposit, and they're asked to look at shortening the period of rental payment, so you don't have to pay the normal 3 months in advance. And we've seen a lot of, deferrals and then monthly payments, and variations based upon turnover, or a significant reduction in rental levels to reflect what appears to be the current market rate as described between those parties. I should stress that there is a knack to drafting rent concession and holiday arrangements. There's a technical aspect to this that's important. And it's this, that until the 24th of June, landlords and tenants who were having those discussions were, under the legislation, deemed not to prejudice the right to forfeiture by having those discussions. As many of you will be aware, the right to forfeiture can be lost very easily. That slice of legislation did not run forward past the 24th of June, so that if from a landlord's perspective you are in serious contemplation of wanting the premises back for any reason, you need to make sure that the way you go about those discussions is protected, principally without prejudice. And then, as to the technical nature of these documents, it's very important that you get the slide rule out and make sure that you cover all of the key elements, whether they're personal, whether they terminate on insolvency, whether it terminates on payment, failure of any of the individual instalment payments that you might have arranged, whether it's to be of a fixed duration, and whether, for example, all of the arrears have to have been paid up before any assignment would contemplate it. So that's probably as much as I have time to say in relation to rents. And then on service charge, if I could just defer to the real experts on this, John and Myra. The code suggests that service charges should be reduced where there's a lack of use of the property, if possible, if service charges are genuinely reduced. Additional service costs, recommissioning, where a building is being reopened, will normally fall into a well-drafted service provision. It certainly should fall into the good estate management provisions. The one that is probably a very good segue to pass on to the real manager experts in this area is the one that I hope you'll forgive my mentioning. It says the landlord should ensure that all management fees reflect the actual work carried out. Well, I've always felt that, that the chartered surveying profession does a very good job of that, but it's the very presence of it in the code seems to suggest that sometimes the fee arrangements don't match the work. But anyway, on that tendentious note, Ian, I'm going to pass back to you.
Thank you very much, Robin. And there's a hell of a lot of detail in there, and obviously, with all the talks that we do, we put up the slides on WG Hub Live on our website, so you can delve into some of the detail if you really need to. I'm sure that's fine, isn't it, Robin?
But absolutely, and please do come back to me if there's something you want clarified. I've had to do it at a lick and at a fairly high level, but the devil is in the detail, and I'm more than always glad to help out.
Absolutely. Okay, fantastic. Right, so we've got a few questions here going on. Can I just ask you? There's a question here. Could you ask me about what are commercial property landlords and tenants? What should they do if the lease is going to expire within the next year or so? Is there any sort of tips for landlord and tenant of what they should do?
Yeah, I can take that one if you like.
Great. Okay.
Yes, there are. I think it's always the case with commercial property lease expiries that both landlords and tenants should look at the strategy very early on. If the lease is protected by the 54 Act, then it's very procedural, the process of renewing a lease, and you have to serve notices to bring the lease to an end and to start discussions for a new lease. that are at least 6 months, between 6 and 12 months before the lease expiry. Now, anyone with a lease that's expiring roundabout now or in the next 12, 18 months, they should think about the strategy very early on. From a tenant perspective, if the tenant expects the rent will go down because the market's changed, then it may well be that if they want to renew the lease, then they should be looking at serving a notice nice and early so that any rent reduction comes in as early as possible. Conversely, landlords, they need to not automatically serve a notice. It depends on where the rent lies. So I think what I'd suggest is if you've got a lease renewal coming up, then you consider it a good 9 to 12 months ahead of the date. If it's contracted outside of the Landlord and Tenant Act, it's still important to consider your options nice and early. Try to understand what the other side's intentions are. Your tenant would have no automatic right to a renewal, so if the landlord's likely to oppose, then they've got to start thinking about relocation options.
Yeah, okay. Have you got any practical application there, Myra? Have you seen anything in this field?
It's just a case of opening negotiations early, and we're lucky that our landlords are quite supportive of their tenants. We've just actually signing off on a deal now for the tenant to enter into an additional 10-year term. But the landlord's been fair with that. Prior to COVID, they had actually already agreed the rent, and then as COVID happened, even though it was all signed up by the heads of terms, the landlord did renegotiate with the tenant in order to keep them in occupation and keep the lease going forward. So that's it. It's just keep talking to your landlord, and it's amazing what deals they will agree to protect their tenants and keep their investment viable.
Yeah, no, thanks for that, Myra. Just to say, we've got our own Stephen Martin here, tax guru. Can ask all the tax questions, answering those. So if you've got any, you please use the Q&A, get those questions out, take advantage of these specialists that are on the program, the event today. So we have got another question here. So I think we're back to the presentation here a bit. So how long are these provisions likely to last? So I think we're talking about the breaks here. I'm considering moving my business and I have an option to extend as opposed to a break. So the effect is the same, he's suggesting, but finding premises to enable me to move is difficult currently. I could do with more time, but not trigger the whole of the 2 years in the option. Is anybody got any solutions there for our viewer?
I think one of the things that your questioner needs to consider is what would be the impact of not exercising the option in terms of the rights that he has under the 1954 Landlord and Tenant Act. Because if so exercising the option with a lengthy term in a circumstance where he's seeking potentially other premises on different terms is the mistake he's trying to avoid. But time is on his side if it turns out that the landlord has not served notices of the kind that John's referred to. But I think so assuming that he's got rights under the 54 Act, he can continue on as long as he is occupying all of the space that he'll have to occupy the space that that he wants security for. And then he can actually discontinue on effectively 3 months' notice. So that probably provides him with the escape route from exercising the option. But he really a lot depends on when the reversion kicks in, and I think he probably needs some advice rather urgently on the premises that he's trying to the move that he's trying to tee up. But that I think is the technical answer anyway.
Okay, that's great.
I'd agree with Robin on that. It does absolutely depend on whether it's a protected lease or not, as to what action is there, and it is an option just to hold over. But like with many cases, I think dialogue, speak to the landlord early on. We haven't really got enough information there to consider it. what's the rent payable under the option agreement? Is it fixed? Does it carry on at the old rate? It might be that the rental value has declined. So you might want to have a discussion with the landlord, not exercise the option, but hold over and try and renew the lease. But speak to the landlord nice and early on. If you can switch or if you can introduce into the option for 2 years a rolling break on 3 months' notice, maybe agreeing to a different rent that you might otherwise agree. If the principle would be that you pay for a little bit of extra flexibility. So I think early dialogue and get some sound advice over the nature of the existing lease and what your obligations are if you do exercise the option.
Yeah. So it sounds like it's all about talking, getting some advice up ahead, and getting a good plan in place. So that sounds that's relatable to a lot of events in our commercial lives, I guess. So, actually, we've got a question come in from one of our regulars, Mike. Sort of a landlord type question. So, is there a risk that tenants will not pay the rents if the lease is about to expire? Now, is there anything one can do to avoid that situation? Wants to take that, Myra? Would like to take that, John?
There's the thing is that it's obviously you've got to allow the tenants the flexibility at the moment. There is always a risk that they're not going to pay the rents, but they are bound. All the legislation does is allow time. It doesn't remove their right to pay the rent. I mean, at this, if we had this situation come up, we would be passing it over to a solicitor to deal with. My role in all of this is to negotiate with everybody before I pass it to the solicitor. But yeah, nothing in the legislation that's been sent out actually gives them the opportunity to not pay the rent. That they're still liable to pay it.
So we still have an obligation in there.
I think, firstly, it's going back to the theme that we've been saying. It depends if the lease is protected by the 54 Act or it's contracted out. If it's contracted out, then a landlord wants to be taking certain measures and actions if the tenant is still in occupation after the lease has expired. That may involve not collecting rent because you don't want to give them landlord and tenant rights to a renewal. So I think it depends whether the lease is protected or not. If it is protected, and if neither side has served any notices in accordance with the Act, then the tenancy will continue. It doesn't automatically come to an end, and it continues on the same terms and rental as the old lease until until the landlord or the tenant takes action to bring it to an end by serving a notice in accordance with the Act. The obligation remains. If notices have been served, but negotiations or the lease hasn't been completed, the tenant is still liable to continue to pay the rent under the old lease. I think Robin can correct me on this, but once the lease has been agreed, determined, there may be a question of what's called interim rent, which is the amount of rent that's payable from the the date specified in any notices up to the new lease clicking in. It's a little bit of a complex area, but it is something that is there and is likely to become a bit more contentious, I suspect, for proceedings that were started pre-COVID and are going to be agreed or determined post-COVID.
Yes, and I agree, and I think it'll be interesting to see whether, in fact, we have some legislative change of a temporary kind to the notice periods under the 54 Act. But to deal with the one aspect of the question that we probably haven't got at, it is right to say that apart from the fact there's a stay on proceedings, there is a massive backlog in the courts already. So the chances of any kind of successful outcome through court proceedings is low. That's apart from the stay on proceedings. What I would say is that if the premise of the question was that the tenant was going to go at the end of the term, didn't want to renew, and was not paying his rent and seemed unlikely to do so, there is no prevention under the temporary arrangements there's nothing to stop the landlord forfeiting the lease for reasons other than a non-payment of rent. So you would need, let's say, to get the lease back early. And you need to explore the possibility of forfeiting for other reasons, for example, tenant insolvency or some other breach. But then, of course, if related to repairs, you've got to go through a whole procedure relating to non-repair. So I would look at that. But otherwise, the bleak answer to the question in the event the tenant doesn't want to renew is no. You've got stone and you've got blood, and I'm afraid it's just not. There's nothing there for you at the moment.
Right. Okay. Obviously, well, thanks very much from Mike. Yeah, he appreciates your answers there, team. I've noted from the attendees today, from our viewers today, that we've got a few sort of like they're landlord and tenant, if you like. So they have their own maybe a partnership, and they own some land and property in that, and then their business is a tenant. Is there any particular issues at the moment where the tenant of their own business isn't doing so well because of COVID, or they're receiving other types of support? Is there anything they should do? That's an open question, and I've only just I'm springing it on you a bit, guys. But I just feel that the audience might have some questions in that regard as to their sort of mixed relationship between the like if you're a trading company and them as a landlord. No.
But I don't think this is one for me. But I note the conflict of interest which sits right in the middle of your question. And if you were to take professional services, for example, it's frequently the case that members of a professional partnership might be landlords as well as through their limited partnerships, tenants of their own business. That makes for interesting discussions. But I don't think I can. I don't think this one is for me, apart from to make that rather obvious.
Fair enough. But there's still an obligation there for the conflict of interest, yeah.
I've got some experience where, for example, a company's pension fund may purchase a property in a SIP arrangement, for example, and then lease it to the company. And in my experience, generally speaking, there's a pension provider that looks after that because there's a lot of due diligence to go through and procedures. And it is to a large extent a landlord and a tenant relationship. For example, when there's a rent review due, if it's an open market rent review due in a lease that's between a SIP and a occupying company where there are common directors of the occupying company and pension beneficiaries, the pension provider will often still want the advice from a professional or chartered surveyor to carry out an independent rental valuation to say, yes, this is open market, it's not above, it's not below. I think there are all sorts of financial regulation issues that they have to go through. So there is that sort of still a legal link between the landlord and the tenant. But having said that, if the tenant is in trouble, why treat it differently? If both sides are agreeable, then speak to the pension provider and say, this is the situation. We may need to have an adjustment to the deed of variation or some sort of temporary relaxation there. But I think that usually there is still a legal landlord and tenant relationship there.
Yes, and if I could just add to that, because I think there's a really good area where one party is effectively paying on both sides of the line. Actually, the perverse scenario around SIP arrangements is that the tenant almost always wants the rent to be as high as possible, which is almost unheard of in any other commercial context. And of course, it lies within the power of his SIP provider, subject to the regulations, to do all the things we've been talking about, to waive, and so forth. But I would have thought probably in terms of maximising allowable losses in your business, you might want to keep the rent is the last thing you don't want to pay. Subject obviously to your other commercial constraints.
Yeah. Following on that point, when you lost that sound for a bit, I did touch on valuations, and just because I do work for a pension provider, they don't occupy any of their units. It's collective investments, and they're all occupied by others, but they have their periodic review coming up, valuation of all their properties, and that's it. We've had to provide an awful lot of information about who we've given concessions to, how much that concession is, how long that concession's for, and when the return can be expected, and that's all being built into their current valuation. So I'd echo that. Generally, if I would assume if they are the tenant themselves, they would want to keep those rental values going through, because it does affect the value of their investment. The valuers aren't obviously, the service charge side of it doesn't come into it, but our landlords have cut concessions on service charge as well, just to ensure that the tenants have got the ability to remain within the unit.
I've been talking to Stephen about the tax aspects of unpaid rent and that sort of thing, and actually balancing the rental relationship between the landlord and the tenant. Because obviously we have a lot of clients who have that situation where purposely the property might be in a pension scheme, and you were saying about the rental, getting that balance, isn't there, Steve, in terms of the what HMRC feel about charging rent?
Yeah, absolutely. So kind of, although the tenant might not be paying the rent, if their accounts are prepared on the accruals basis, they'll still get the tax relief, although they've not been paying it. Whereas if it's prepared on the cash basis, then you're automatically getting kind of bad debt relief as you go. Yeah.
Well, that's it. So that's great. Thanks guys. I'm just checking the questions. We haven't got too far to go now. So have you got anything in particular? I know Myra deals with sort of more, what do they call them? Multiple.
Yeah, so we deal with a lot of tertiary shopping centres and industrial estates, that sort of thing. So our landlords have actually got their own vested interest in making sure they support the tenants, because the last thing they want is a domino effect. Appreciate tenants may not be as well looked after if their landlord investments are more standalone investments, because then it's a bit more out for themselves. But with us, that they've actually been really fantastic. But it does start with communication. Don't ever assume that your landlord knows what you're going through. I've had businesses that did actually remain open all the way through the COVID crisis, but because of the additional measures they've had to introduce, their finances have been hit, and the landlord has still allowed them concessions, because the end game is to have viable businesses for everyone to come back to. And they know if 3 or 4 units starts to fail within their development, they're going to run the risk of losing the majority, because they need to keep the footfall coming to that centre. So I'm lucky in the fact that the developments that I manage are more shopping centre location. It is all tertiary, so they've got to think, we're benefiting a little bit from the shop local, that's helping, but they've just got to look after their tenants, but they're not mind readers, so open dialogue.
And I think you'd probably reiterate that, wouldn't you, John?
Definitely, communication is key. Absolutely.
Yeah. So obviously, if you need some help from any of our panelists today, please get in touch. I'd like to thank you very much for taking part today. Really appreciate that. Thanks, Robin, for being the main speaker today, and but for our enforced break, appreciate that. Got me to have a drink, so there you go. But no, and obviously, thank you so much for joining the panel today, Myra and John Baker, and our own Stephen Martin on the tax issue. So thanks very much. I'd just like to just remind you, next week, the Hub continues, 10 o'clock, Friday morning. We have next week a special session on GDPR with a national specialist, Mark Gracie, talking about the effects of data, what you've got to collect, what you've got to do with your employees coming back to work, and if you're in those sectors such as travel and etc. So please join us next week, 10 o'clock next Friday, and thanks for joining us today.